Repeat the question, please.
You told the jurors that prior to putting this on, you weren't wearing anything, correct?
No.
Like, no, you weren't wearing anything, or no, you didn't say
I was
that?
not wearing a shirt.
Welcome back to Time Serve. Buckle up. Because today's case against Luis Contreras spirals into one of the wildest courtroom meltdowns we've ever seen. The state's star witness? He doesn't just trip up, he completely implodes. From contradictions to confusion, vomiting, and even a judge's stern warning. This testimony leaves the entire courtroom stunned. And wait until you hear how it all ends.
Correct? The defense is asking you questions. You need to answer the questions that's being asked.
Can you imagine being the jury here? The state's star witness, supposed to be the most credible voice, can't keep his answers straight. This isn't just a stumble. This is the prosecution's entire case wobbling on shaky legs. Jurors are watching every word, and credibility is everything in a criminal trial. Without it, the case is toast.
Other inconsistency that you had, sir, you had mentioned someone by the name of Ramon to police if you're mistaken.
I don't remember that.
But if you had, do you know someone by the name of Ramon? Sorry, sir.
I don't remember Ramon.
Now, did you feel in fear when the defendant was going through your items?
Yes, I did.
What was
Because I had asked him, I'm sorry.
What was your fear?
My fear was that he was looking to steal from me.
Did you think that he was going to hurt you?
Not until I saw the knife.
When you saw the knife, what did you think?
I said, yeah.
Notice how his fear escalates only after seeing a knife? That detail is huge. In law, the difference between theft and aggravated robbery often hinges on the presence of a weapon. But jurors will ask, if he was so scared, why didn't he call 911 immediately? These contradictions are going to matter.
Now I need to worry about, I'm looking for my phone, wanting to call 911. I can't find my phone, so I went towards the door to open it up, ask him to please leave. If you don't leave, I'm going to go get my neighbors.
The name of Ramon? Sorry, sir. Were you in fear for your life?
Yes, I was.
Pass the witness.
Defense.
Thank you, Judge. Mr. Loomer, good morning. I'm going to be asking you some questions. Mr. Loomer, I promise you that the purpose of my questions are not to confuse you. They're not to mislead you. They're just questions that I need to ask for the jury to understand what happened here. Okay. And I'm going to jump a little bit out of order. And so the first thing that I want to talk to you about is this. You told the jurors that you drove around, was it the Vance Jackson area? When you, no?
No, I told him, no, I didn't tell jurors.
Okay. Let me be a little bit more specific. What area or what gas station did you drive by when you picked up Mr. Contreras?
I went to the 7-Eleven on 410 in Vance Jackson, and then on my way, I'm trying to think.
Well, here.
Fear escalates only after seeing a knife. That detail is huge. In law, the difference between theft and aggravated robbery often hinges on the presence of a weapon. But jurors will ask, if he was so scared, why didn't he call 911 immediately? These contradictions are going to matter.
Let me help you with that. So you went to the 7-Eleven, right?
To get cigarettes, yeah.
Okay. You told the jurors that you're driving around and you see an individual that in your belief appears to be dead, right?
I thought he was, yeah. He wasn't moving. He was in a strange place. I've never seen anybody be at before.
Okay. And so you believe he's dead, but yet you don't call 911 or EMS to report somebody that you believe is dead, correct?
Okay, so can we backtrack here? I drove down Moss Rock.
Give me 1 second.
Okay.
Let's go in order.
Okay.
You just finished telling the juror you thought that individual was dead, correct?
The first time I saw him, I drove by Moss. I I drove down Moss Rock to go to the 7-Eleven. As I drove by, I saw somebody
I'm
laying there.
object to non-responsive, Judge.
All right, that will be sustained. You need to listen to the
I
question.
know,
No,
but it was in the wrong
Stop.
order, right? I'm sorry.
you need to listen to the question
Okay,
and answer the question that's being asked of you, okay?
okay.
All right, thank you.
Okay, Mr.
State-
Loomer, so very simply,
I'm sorry, defense.
yes, Judge. Very simply, Mr. Loomer, you see this individual and you believe that individual is dead, right? Is that a yes?
Yes,
And yet you don't call 911 or an ambulance to report that dead person, right?
Right.
Okay. What you tell the jurors is that you still go a step further and you approach that individual that you believe to be dead, correct?
Right.
And you just told the jurors you went to the store to get cigarettes, right? Did you get the cigarettes before or after you saw the individual you believe to be dead?
I got cigarettes before.
Okay. So it's safe to say that you had just gotten in your car after having a conversation with the cashier and getting your cigarettes, correct?
No,
Okay. Let's take it a step further then. You get in your car, and yet not only do we know you don't call law enforcement or
I'm
the ambulance.
confused. Your Honor, I'm confused. He's not doing the right order.
Excuse me, sir.
I'm sorry. I'm
Sir?
confused.
Here's where the trial grinds to a halt. A witness who repeatedly says, "I'm confused," undercuts the state's case in real time. The defense doesn't even need to press too hard. He's unraveling himself. Viewers, what do you think? Is this confusion genuine memory gaps, or is he dodging the truth?
Just one moment. Ladies and gentlemen, if I could have you all step outside just for a moment. Wish to invoke the rule?
No, ma'am.
All right. Are there rules? Do you understand? Ask them. Please be seated. Mr. Loomer, I'm going to explain something to you, and I want you to listen to me very carefully and internalize what I'm saying. The state asks you questions. You answer their questions, correct?
Correct.
The defense is asking you questions. You need to answer the questions that's being asked of you. The defense attorney can ask his questions however he wants to ask them, and he can ask them in whatever order he wants to ask them. Do you understand?
Yes, ma'am.
So there is not to be the back and forth with me
Yes, ma'am.
where you're telling me, well, Judge, he's asking the questions in a different order. He may ask whatever questions he wants to ask. If there's an issue with the question, then the state may or may not choose to object if it's a question that's objectionable or against the rules. Do you understand?
Yes, ma'am.
So there is to be no comment with me.
Yes, ma'am.
That moment with the judge? Critical. She had to stop the entire trial and lecture the witness like a student out of line. Jurors see everything: tone, patience, frustration. And when a judge has to intervene just to keep order, it signals this witness is a liability, not an asset.
About how you feel the defense is asking their questions. Do you understand?
Yes, ma'am.
Is there anything that you do not understand?
No, ma'am.
All right. Are they? All right. So the jurors are going to be on a short break.
Yes,
So
Judge.
as soon as they finish with their break, we're going to come back.
Yes, Judge.
All right. Sure.
Right here, Judge.
All right. Thank you. Can you bring them in?
All rise for the jury.
Oh, please be seated. Right. All right, defense, it's your witness. You may.
Thank you, Judge. Okay, Mr. Loomer. Remember what I said, okay? I'm going to ask you some questions. I'm not trying to mislead you or confuse you, okay? But I did tell you I am going to go out of order, okay? All right. So you didn't get out of your car to notify the gas station attendant that you believe to be a dead individual outside of the store, correct?
No,
Okay. And you just told the jury you didn't call the officers or law enforcement either, correct?
no,
Okay. But yet you approached them and said, hey, are you okay? Right?
yes,
And you didn't ask them either, hey, let me call you an ambulance or the fire department, right?
no,
Okay. Now, let's just get this out of the way first. At that time, March 29th, 2022, you weren't employed with Heaven for Hope, correct?
repeat the question, please.
Yes. On March 29th, 2022, you were not working for Heaven for Hope.
No.
Right? You weren't working for Catholic Charities, right? You weren't working for the Salvation Army,
No,
correct? You weren't working for the Hope House,
No.
correct? You weren't working for any nonprofit organization that helped homeless individuals on the streets,
no,
correct? Is that right?
no,
Okay. And yet you're telling this jury that you picked up this individual and took him to your house, correct?
yes,
Think about this. He claims he was so scared he stayed up all night watching this stranger. Yet he also says he let him into his house, let him sleep, and didn't call police. Does that make sense? Jurors are smart. They're piecing together that his story just doesn't add up.
Okay. And so you're telling the jury that you did it out of the kindness of your heart, right?
yes,
But yet you told the jury that when you got home, the first thing you said to that individual was, don't touch anything, right?
yes,
You told them, leave your stuff in the front door,
yes,
right? According to you, you were so worried about this guy that you slept or that you stayed on the couch awake the whole night.
yes.
By the way, you just told the jurors that before, can I approach Judge?
Yes.
I'm going to show you what's important. That's State Exhibit number 5, Mr. Loomer. You told the jurors, and I'm going to hold it up here for them to see. You told the jurors that that is the, what do you call it, the scrub top or the, right? But this top was given to you by EMS, right?
No,
No?
no,
Okay, so who gave you this?
that is mine.
That is yours? Okay. Because the question that was asked to you is, what were you wearing before this? And the answer you give to the jury is that you weren't wearing anything, right?
And I'm going to object. That's mischaracterization for prior testimony.
Overrule.
Repeat the question, please.
You told the jurors that prior to putting this on, you weren't wearing anything, correct?
No,
No, you weren't wearing anything, or no, you didn't say
I was
that.
not wearing a shirt.
So you weren't wearing a shirt. Okay. So you have this strange individual. By your own admission, you're scared, right? And you're awake the whole night because you don't trust them, right? And yet you feel comfortable enough.
Now this part is almost surreal. He says he was terrified, but comfortable enough to sleep without a shirt, next to someone he supposedly feared. That detail sounds small, but in trials, it's exactly these inconsistencies that destroy credibility. If one part doesn't match human behavior, jurors start doubting everything.
To sleep with a shirt off. Right. To stay awake
Yes,
with a shirt off.
yes,
Okay. And you had your phone with you at all times, correct?
doesn't anybody.
Right. So you did.
I mean, yeah, it's somewhere around the house.
Okay. But again, just to make sure we're understanding you, right? You're told the jurors that this individual wakes up and he starts rummaging through your house, right?
Yes,
You told the jurors that you had your phone with you, right? But yet you don't call the cops, right?
yes,
You don't call them, right?
yes,
Yes, you call them, or no, you
No.
don't? You don't call them?
No.
Okay. Now, again, jumping out of order. Do you remember talking to a detective De La Rosa?
I don't know specifically who I
Do
talked
you
to.
remember talking to a detective on March 30th, 2022?
I talked to a lot of cops and detectives.
Okay.
I don't know who it was.
All right, and we'll get into that, okay? Let's talk about one of the inconsistencies you've given throughout this trial, okay? When you talked to Detective De La Rosa on March 30th, 2022, do you remember talking to him?
Yes.
Okay. Do you remember telling him that you claimed to have met this individual through a mutual friend by the name of Ramon
No.
or Raymond? You don't remember that?
No.
Okay. So if Detective De La Rosa puts in his report,
And here's a bombshell. The detective's report says he mentioned a man named Ramon, but now he denies it. So either the detective is lying, or the witness is. In court, that kind of contradiction isn't just awkward. It can be devastating for the state's case. Who do you believe here?
that you told them on March 30th, 2022, are you telling this jury that Detective De La Rosa Ramon came into this picture?
No.
You're telling the jurors that you don't know an individual by the name of Ramon.
Yes.
Are you sure about that?
Yes.
Okay. So you take this individual to your house and you're telling the jury that the clothes that that individual was wearing, you don't give him those clothes, right?
No.
Okay. I think you told him he started rummaging through your house.
Not my clothes.
Did you give him anything to wear?
I don't remember.
Did you just not tell this jury that he was rummaging through your house and he took some clothes?
Yes, he took 2 pairs of sweatpants after I left the house to my neighbor's house.
So, okay. So when, let me step back again, not trying to confuse you. Okay. So when you take him to your house on March 29th, 2022, does this individual shower?
I don't know.
Well, how big is your house?
3-bedroom, 2-bath.
And you just told this jury that you had an eye on him at all times, correct?
Yes. Yes.
Right? Because according to you, you've never done this before, right?
Yes.
And you're telling this jury that you don't know if the individual that you don't trust took a shower that night?
I don't remember.
Okay. When this individual sleeps, is he wearing
He
anything?
wasn't on the sofa. He was in a chair.
The recliner. When he's sleeping on the recliner, the chair, let's just use your words. On the chair, is he wearing any clothes?
Yes.
What is he wearing?
I don't remember.
Okay. Your dog is with you at all times,
Yes. By my side.
by your side. All right. Now, let me go back a second. This morning, Mr. Loomer, and I'm fast forwarding a couple of years, okay? This morning,
Sorry,
June
say that again.
Yeah, I'm fast forwarding a couple of years. All right. June 14th, 2023. All right.
Fast forward a year later, he allegedly gives yet another version of the story. That's 3 different accounts across police, neighbors, and court. Jurors don't need to be lawyers to see the problem. Shifting stories usually mean someone's hiding something. Comment below. Do you think he's lying or just that unreliable as a witness?
I had a meeting with the gentleman over here to my right, correct?
You're talking about today?
Yes, June 14th, 2023.
Yes.
Okay. How long did you meet with him for?
I got here at 8:15, and I met with him and Rose until we came down here at 10.
Okay. And during that meeting, you gave to the state, the gentleman to my right, you gave them another version of what happened on that day, correct?
No. Another version of what?
Of the incidents that happened on March 29th and March 30th of 2022.
No.
Okay. Let's take it again, one step at law enforcement, right?
Yes.
And you tell your neighbor that day, you told your neighbor, I think her last name is Sertucci, right?
I don't know.
You don't know the name of the neighbor who lives across the street?
She just moved in.
Okay. You tell this woman, I submit to you that her last name is Sertucci. Okay. You tell this woman, hey, call the. You don't remember telling that to.
No.
So if Mr. Tucci comes in here and says, Mr. Loomer told me my house was just broken into.
She was misunderstood. She misunderstood because I did not say my house was just broken into.
And you told her that this gentleman, this individual went to your house that morning to burglarize it, right?
No,
You didn't tell her that?
I did not tell her that. I told her call 911. That's all I said. I'm bleeding. I'm screaming. I call 911. Call 911.
Okay. That same day, March 30th, 2022, multiple officers go to your house.
Yes.
Okay. I submit to you, one of them is Detective De La Rosa,
Okay.
right? He interviews you as to what happened, correct?
Okay.
Do you recall that?
I was interviewed by quite a bunch of cops.
Okay.
Yes.
And while you're meeting with him, your top shirt, you're not wearing a top shirt or a shirt, right?
Right.
Okay. And so the first story, your version of the events, is that this individual, right? This individual goes to your house and robs you, right?
No.
Do you not tell Officer De La Rosa that this individual goes to your house, burglarizes your house, and leaves?
No.
Later on that day, De La Rosa meets with you a second time, if you recall that, right?
It's all a blur to me, sir.
Okay, Mr. Loomer, let me just ask you one simple question, and I want you to be honest to the jury, okay? Are you telling this jury that you just do not remember anything that happened?
No, I'm not.
Okay, but some parts are a blur
Yes.
and some parts are not.
Yes.
Okay. When you meet with Detective De La Rosa a second time on March 30th, 2022, okay, I submit to you that Detective De La Rosa had just met with the individual who you claim went into your house and burglarized you. Okay. Do you recall Officer De La Rosa telling you your story is not true?
Objection, hearsay.
That'll be overruled.
You can answer the question.
I'm sorry. I'm sorry. I'm sorry. Yet, what? Repeat the question, please.
Do you remember Officer De La Rosa, Detective De La Rosa, meeting with you for a second time on March 30th, 2022, and tell
This is the breaking point. After hours of cross-examination, the star witness literally says he feels like passing out and has to leave the stand. Imagine the impact on the jury. The prosecution's main pillar just crumbled before their eyes. That's not just drama, it's the case collapsing live.
telling you, Mr. Loomer, your story is not consistent?
Yes.
Do you remember truthful?
Yes.
You remember telling you, Mr. Loomer, let's start with that. That's when you finally, again, tell Detective De La Rosa that you picked up this individual the night before, March 29th, 2022.
I'm sorry. I got to take a break. I feel like I'm going to pass out.
All right, ladies and gentlemen, I'm going to give you a brief recess. You've heard some evidence in this case. You're not start deliberating in your own mind or with each other. I'll let you know when it's time for you to deliberate. You're not allowed to view anything. I'm sorry, the other thing you're not allowed to do is any investigation. Okay, so I'm going to give us a 15-minute break. We'll be back at 11:15. Everyone, please rise for the jurors.
In the restroom. I'm going to throw up.
One pair of pants later.
Does your client have any other pending matters other than this?
I don't believe so, Judge. I think Hank confirmed that the marijuana misdemeanor was not filed.
All right. So, Mr. Contreras, I'm being told that the state is going to file a dismissal in your case. And if they file it, I will sign the dismissal. But I want you to realize something. Whatever brought you here today, you need to change your ways. You understand? Right. You're going to have to do better because your minimum sentence, if this case were to go forward, if the jury would have found you guilty, if your minimum is 25 years in prison, you understand? And what I can tell you as a former defense attorney and a prosecutor, in these type of cases, if a jury finds somebody guilty, usually they don't give 25, they don't give the minimum. Usually they give 80 years or life. As a prosecutor, I once had a jury give someone 99 years in prison. And then when I went back to talk to them, you know what they said? Stephanie, we were going to give the person life, but we thought maybe they would improve. Was that okay with you? So how old are you? You're 36 years old. You need to change your ways. You understand? Okay.
And there it is, the knockout blow. The state folds, dismissing the case against Contreras after their witness falls apart under pressure. The judge doesn't let him off easy, though, warning him that if this had gone forward, he was staring down a possible life sentence. Viewers, what do you think? Did justice prevail, or did chaos in the courtroom tip the scales?